You're listening to the Patenting for Inventors podcast with registered patent attorney, Dr. Adam Diamond, founder of Diamond Patent Law, the #1 source for securing your intellectual property needs. Now, here's your host, Adam Diamond.
Hello and welcome to the Patenting for Inventors podcast, episode 97. What is the Patent Prosecution Highway and what's the speed limit? My name is Adam Diamond, a registered patent attorney and founder and owner of Diamond's Patent Law in Los Angeles, California. I can be contacted through my website at diamondspatentlaw.com, that's D-I-A-M-E-N-T, patentlaw.com, or call me at 424-281-0162. This episode is about how to speed up your patent application using something called the Patent Prosecution Highway. I did briefly mention it in a couple episodes, I think it's episode 30 and 38, about general ways that you could speed up your patent application, but I wanted to dedicate a full episode to this particular way. So what is the Patent Prosecution Highway? As you might be able to tell by the word highway, it has something to do with patents going fast. And it talks about different methods of getting your application examined quicker than the normal route. And one route is called the Patent Prosecution Highway. Basically, if you have a patent application in lots of different countries and it gets allowed in one country, or you have a positive patentability opinion, you can tell a bunch of other countries to move your application to the head of the line because it's already been allowed somewhere. Now, this doesn't guarantee that your patent will be allowed in any one particular country, but there's a higher chance than normal that if your application got allowed in one country, it will get allowed in the U.S. as well. So, and in this episode, I'm going to focus on the U.S. And this is how it works. There are certain countries that have agreements with each other that if at least one claim has a final ruling of being allowed, then you can fast track your patent in a different country. There are lots of good things about this, but one good thing is that there's actually no extra fee to the patent office to request this. Now, there may be some nominal attorney's fees to request it and do all the paperwork, but in general, that shouldn't be that expensive in the grand themes of getting your patent. The countries that have agreements with the U.S. Patent Office are Australia, European Union, Canada, China, Israel, Japan, Korea, Russia, the UK, Argentina, and there are several others. Some of this is a pilot program, and hopefully the pilot program will continue. But if you want to do this, you get a 2-page form, and it's called PTO SB 20 GLBL. Type that into Google, and hopefully the form should pop up. And it's called a Request for Participation in the Global/IP5 Patent Prosecution Highway Pilot Program in the USPTO. It's a lot of words there, but that's the title of the form. Now, on this form, you'll put in some information about your application, like the application number, the inventor, the title. You put in the country where you got the allowed claim, the application number of that allowed patent or the claim that's been allowed. You put in the type of paperwork that you're showing that you have an allowed claim. Maybe it's an actual patent you got. Maybe it's a notice from that foreign country's patent office of a notice of allowance, and you can attach it, or it's possible if it's available online, you can just ask the United States Patent and Trademark Office to retrieve that document themselves. You also have to submit a list of prior art references used by that patent office, if there is a list of references. So it may be allowed, but the patent office listed, 5 different prior patents that were used in their search, and you'll have to include those as well. On the second page of the form, you list the number of your claims in the U.S. application that correspond with the claim number in the foreign application, and then an explanation of the correspondence. If it's simple, you might say claim 1 in your application is the same as claim 1 in the European application, and in the explanation you say claim 1 in both applications are identical. Now, maybe you're thinking that this isn't much use to you because you're filing in the U.S. first, and you're not going to be able to speed it up using the Patent Prosecution Highway. And that might be true, but if you got an allowance in the U.S., you can speed up your prosecution in other countries based on your U.S. allowance. And you'll have to talk to the foreign patent attorneys on what they'll need from you in order to speed up your application in their country. But most likely, the way you're going to use it is if you file a PCT application. And if you want to know more about those, you'll have to go back and listen to all my PCT episodes. That's an international application. And you get an opinion pretty early on from a PCT examiner if you file a PCT application. And that's usually before you even file your U.S. application if you file the PCT application first. Now, if you remember, you get what's called a written opinion from a PCT examiner or an international preliminary examination report, depending on if you're paying for extra stuff in Chapter 2, I go into all these details in other episodes. Now, lots of times, if you're a U.S. applicant, you'll file your PCT application in the United States, and you get a PCT examination in the United States from a U.S. examiner, but it's all part of that international office. If you get a positive patentability opinion, you want to look for a form called PTO SB20 PCT US. It's called the Request for Participation in the Patent Cooperation Treaty Patent Prosecution Highway Pilot Program in a U.S. application where the USPTO was the ISA or IEPA. It's a great name for a form, I'm sure you're all thinking. What you do is it's pretty similar to the other form I talked about. You fill out some information about your patent application. You put in the corresponding PCT application number, the date that it was filed, some other things. And there's a list of documents that you should attach, such as the written opinion itself. You want to include a copy of all claims that were indicated as having novelty, inventive step, and industrial applicability in the PCT application. An information disclosure statement. I had a whole episode about those. And copies of specific prior art that the Patent Office wants. So references that were used in that opinion. You have the same page where you list the corresponding claims in the U.S. application compared to the PCT application. Now, there's no guarantee when your application will be examined if you request to have your application examined using the Patent Prosecution Highway, but the USPTO does say this typically between 2 and 3 months. Now, this is really fast compared to 1 to 2 years, which seems typical these days of how long it takes a patent application to get examined if it's not expedited. And what are the chances that you get an allowance in the U.S. if you got a positive opinion from some other entity? I read on the PTO website that overall allowance rate is about 84% for a Patent Prosecution Highway and 53% for regular applications. So it's not a slam dunk if you get one patentability opinion from one entity, whether you'll get a patent in the U.S., but it does boost your odds if you got a positive patentability opinion. So this is something you should really consider doing. If you got an allowance from another country or a positive opinion from your PCT examiner, there's not really much negative except for some attorney's fees. And it's just good to let the U.S. examiner know that some other examiner thinks that your invention is patentable, because it will plant a seed in the U.S. examiner's head that it's okay for your invention to become a patent in the U.S. And if you want help with your patent application, trademarks, copyrights, responding to rejections, appeals, anything else related to your invention, you can contact me directly through my website at diamondpatentlaw.com. That's DIAMENT, patentlaw.com. Email me at adam@diamondpatentlaw.com or call me at 424-281-0162. I'm Adam Diamond, and until next time, keep on inventing.
Thanks for listening to the Patenting for Inventors podcast with host Adam Diamond. If you enjoyed the show, please rate and review on iTunes. The contents of this podcast are intended for general informational purposes only. The facts of every legal matter are unique, and the content of this podcast should not be construed as offering legal advice for your specific legal situation. For more information and help with your own intellectual property needs, contact Adam Diamond at patentingforinventors.com. That's patentingforinventors.com. Or call Diamond Patent Law at 424-281-0162. The preceding information may be considered an attorney advertisement and does not establish any attorney-client relationship.